Attorney Brian Parker here with another exciting video. Another reason why it's exciting, it's the first day of our collectionstoppersolutions.com 2.0. We've listened to our members, clients, customers, and they've, I guess the best way to say it, we've had navigation issues. They have members eventually get to where they need to get, but I'm often fielding calls about missing videos or documents. So my web person, Natalie, has just been busting her you-know-what to make this happen. Sleepless nights, just craziness, just mad at me but not showing it. And she has done a great job. I hope you agree. Check it out. Here is her website address, Shazam, in case you need some great site work done. But let's get to the meat of the act here. Today is responding to collection request to admits. As I always say, snooze alert, but that's not true. You still have to answer them. So we are a one-stop shop. We're trying to meet every need that you have and find solutions to your collection problems. And one of those is you get a nasty debt buyer or a creditor send you request to admit. So what do you do? First of all, it's all about attitude. It ain't that big of a deal. Easy for me to say, right? But it isn't, especially if their desire is not litigation-based, meaning they're just being spiteful. They'll kick themselves in their own butt. And again, you can use their documents and your counter affidavit against them. So let me put up the first instructions for you to consider. Shazam. And that is what I want you to think about. First of all, think about subscribing, liking, loving, checking out the website, thumbs up, tell us what we need to do better. Whatever you need from us, I'll do a video for you, all right? And try to get you the templates. They are templates that I put on there. Just apply your state and facts. So first off, requests to admits aren't that big of a deal. They're really not worth it. No one's searching for the truth. There's just one thing you got to be careful about. Usually, I use them and I rarely do. And when I do use them, I'll maybe send 3 to 5 just to make a point, just to show the other side. Because some, debt collectors, they got tons of work and they're not going to listen. They're just cursory review of how you responded. So I'll do a request to admit just to say, hey, did you notice? Please admit that this is the truth. And that usually settles the case. In 30 years, check this out. As far as answering requests to admits, in 30 years, I don't recall one collector, plaintiff, creditor, bad guy, whomever, reaching out to me after I responded to request to admits and saying, hey, did you mean this? Did you mean that? Nobody pays attention to it. It's a Hail Mary. At the end of the game, your team's down 6 points. The quarterback from your own 20-yard line throws it, a Hail Mary it's called. That's what requests to admits are. So don't be too scared of them. They really don't go anywhere, or the receiver drops it or they get intercepted by the rules. The rules are that, you have to follow the rules, but there's really no oomph or sanction or punishment. But there are, and I'll show you what you've got to look out for. So now let's put the general rule for answering requests to admits, Shazam. You got to respond to them. Generally, it's 28 days. So I advise you, when you get requests to admits, more than any other requests, be it requests for documents or interrogatories, put these on your calendar, whether it's electronic or paper, something. I always, when I'm really need to know something, I write everything on my bathroom mirror, all my goals and all my look out fors. So put it in your calendar for at least 10 days before it's actually due. So if you get it on the 10th of August, it's going to be due, let's say the 8th of September. That's on a good day. because then you can really argue, well, the first day I get them, and the court rules say this, especially federal rules, the 10th would not be the first day. So it goes back and forth. I'm not going to get into any of that. So we worry about the mail. We worry about the responses. Just get your response to them within 20 days. All right? Check your court rules. But whatever your court rule says, you got to respond to a request to admit, chop off 10 days and get it behind you, right? So you don't worry about it. That's the thing that keeps him up at night. Again, as I said before, these aren't that big of a deal. They're usually badly written and they don't mean anything. And they are a way for the other side to not to have to work, meaning they'll get, well, let's go on and I'll show you exactly what I mean. When you respond, and hopefully, Cindy, the rules are still up there. If I didn't do it, general rule again, Shazam. You can break it down. So you could admit a part, deny a part, or say, I just have no idea what you're saying, objection. So check your state rules for what objections to use. I always like as an objection, as I say in the 4th paragraph, facts not in evidence. A lot of request submits are based on the way the creditor sees things, and it's usually an error, especially because they're paperwork. Creditor or debt collector, because you can see, because if you've followed all my videos, you've ripped down, you've checked out their pleadings. So I say facts not in evidence, objection, I can't answer this. So facts not in evidence shows up in a lot of my responses. And speaking of responses, attached to this video at collectionstoppersolutions.com 2.0, it's not 2.0, but that's what it is, will be a ton of word templates on how to answer these things. You can just take my word template. There's creditor request to admits. There's creditor securitization admits, student loan, debt buyer, you name it. I've attached a bunch. It all gets pretty repetitive and it's the same answer. I also have one that I call risky but logical, and I'll explain that in a second. Here's what, again, generally, why what they ask for dictates your response, especially when you look at my templates. If the thing is poorly worded, and they generally are, you can object going, I don't have a freaking clue what you're talking about. You don't have sufficient information because of the poor wording, or, and this happens, they'll go, admit Exhibit A, blah, 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 and they don't attach Exhibit A because, frankly, a lot of this stuff is based on their lack of knowledge of what you're saying or even what they're saying, because if it's a debt buying situation, there's just no proof there. So they're saying, please admit the loan agreement and then admit that we own it, because they can't. But if you fail to answer, now we're going to look at the caution. So let's put up the caution, Cindy. Shazam, ski. So there is one, as I alluded to, sanctionable 1.5. If you don't answer the request to admit, whatever was asked for you to admit or deny, actually they should be called request to admit or deny, but they're called request to admit. If you don't answer and there's a blank space, and after, let's say it's 28 days, you got to respond by, after that, it's automatically admitted. So what, right? Well, most debt buyers load up with things, check it out, that they can't prove. So they leave it on you. They make you do their work for them because you're, frankly, non-represented. And this happens. I get clients like this all the time. I've gotten people out of sticky situations where there's a request to admit. And the way I got out of it is I went in hard on motions to get rid of the responses before we get to the case against my client. So they just settled because it was too expensive. But I don't want to be in that situation because I got to charge my client a lot of money for that. So don't, is this a double negative? Don't not answer. Remember what I said. Get it on your calendar, answer. You may not like your answer or response, but generally, debt collectors, creditors send out request to admit just so they don't have to do the work proving it. What do I mean? When an admission occurs, so let's say you got 28 days to answer, and on the 29th, you are sleeping in bed and didn't answer, there's just no way you're getting to it. That's proof. And you do that to them too. If you send request submits, they fail to answer. Yeah, that happens with law firms. You don't have to do the laborious, painstaking approach to proving the thing that you asked to admit. Once something is admitted, you don't have to prove it. Also, if you deny something, it's another caution as I've got up there. If you deny something, it turns out through proof, factually it's true, the court will sanction. So there's two ways to sanction you with these things. Number one, if you don't answer, on the 29th day, it's admitted. And by the way, let's say you get to it on the 30th day and you go, oh, all is forgiven. I can rest easy. The rule is quite hard. It just says if you don't answer within 28 days, it's admitted. So if you answer 30th and nobody says anything, you've admitted it even though you've answered. It isn't retroactive to when you get around to it. It's a very, if you will, severe and draconian rule that is neither of those things. If you follow my Parker rule, just get it done 10 days before it's due so you can sleep. So watch out for not answering. Watch out for answering where you have clearly not presented something that is true, if you will, and can be factually worked against you at trial. So admissions can hurt you in summary motions. That's the 90% of all the work and goal of a debt collector is get you into a summary hearing. And if they've got admissions because you missed something, you're going to lose that case. Again, the time period doesn't stop, but there is some relief here. So let's put up the release, Cindy. Boom, Shazam. You can ask for an extension on the other side and say, hey, other side, and I would not do it on the 27th day because they'll hem and haw and forget just because they know you're in a bad place. Early on, you may want to put that on your calendar. Within 10 days of receiving these, I will ask for a stip because you're busy or something's happening or you need more information. It's okay. And as a professional courtesy, 9 times out of 10, the other side will grant you an extension. So if anything comes up, you've got an email or letter from them saying, take as long as you want. Usually, if you ask for an extension, have a stip for time enlargement or something, or an email that just says, sure, person, you can have 10 extra days. Now your stuff is due on September 18th. That will protect you, and nobody's going to argue with that. It's the 1 out of 10 person that does it is a jerk. And how you take that is that you put that in your motion for enlargement. You can do a motion for enlargement if they won't agree. And you tell the court, I asked for a professional courtesy and they told me to go fly a kite. And then you put their email saying that as Exhibit 1. But that goes both ways. And here's what happens to me a lot, especially in Florida. Real quickly, I'll do discovery. They don't want to answer because if they know if they answer, the case is over. So they'll file a motion for enlargement of time without even communicating with me. So I know it's BS. So make sure there's that communication with the SI. Communication cures everything. Communication and education cures everything. So especially in Florida, when they do a motion for anything, if you don't set a hearing date in Florida, it just goes on and on. And my brain, I'm like, well, if the motion wasn't granted, your 28 days has passed, even though you filed a motion. So that's how I get them that way. But generally, if someone's filing a motion for enlargement of time and they didn't talk to you, they're up to no good. So anyway, you show communication to the court, and generally they're going to give you what you want, the extension of time. So, and generally, again, 9 out of 10 professional courtesy, they'll give you an extension of time. So the last part, Cindy, well, second from last, I want how to write responses. That's why you came to this video, and I've just been going on and on. Shazam, in writing your responses, here's a good tip. Just cut and paste their questions. It used to be in the old days, seriously, I've been doing this for 30 years, you'd have to type their questions, then type your answers, send it up to the client, and this was a very laborious task before PDF, so there was a day. Now I just go, here's their responses, PDF all their questions. I've got template answers to the usual questions that I'm giving you. Cindy, just put up a list there. Cindy put on the screen next to, as I announce, Shazam. That is everything that I will add to my video for you. So I'm making this so easy for you to respond. I've given you a variety of questions in the form of creditors, student loan, debt buyers. They'll match up to what is being asked of you. Take my word template. If it fits your state law facts, drop it in. Done. So in your responses, get back to Cindy, put up in writing your responses, Shazam, cut and paste their requests, as I said, use Adobe, etc. I've got my examples. Be human in your responses. The minute you start talking like an attorney, you open really yourself up to more liability. You want to go, what? So your answer should basically say, I have no idea what you're saying. I can't discern what you're asking me. I can't decipher. And that allows you to say, I can't answer. So you'd either do an objection, I can't understand, objection irrelevant, facts not in evidence. But whatever you do, back up your objection. Do not put an objection in without backing it up. Objection, I have no clue what you're saying. I've read and read this thing. It makes no sense. So be human. Rules are there for our protection, but humans are the ones that apply the rules. So be human in your responses, and you will get latitude because you are a non-represented person. Enjoy that, because it feels bad that you don't have an attorney, but there's a lot of positives from not having an attorney. Believe me. So have objections and waivers up front. So you'll see my examples, all those several examples. I have 2 pages of objections, waivers, you shouldn't do this. And I also put in, as far as my answer, my affirmative defenses, my counterclaim, I do not waive those. It's a belt and suspenders, because nobody's saying you do. But if it comes down to someone filing a motion against you, go, look, I told them that I'm not doing this. And, or Parker, you didn't answer. Well, if you look at my answer, my actual answer, as far as my not answering a request to admit, Your Honor, I say very clearly that I don't owe this debt, and they have not proven that I do to them. So how am I supposed to answer something that doesn't exist? And by the way, Your Honor, here's where the gap in their chain of title is. So you turn any motion against you into a chance to talk about your case, smack them. I love it when new attorneys threaten motions, because I'm like, okay, go ahead and do that. And then I get a chance, a free shot to just vomit all over them something they do not want to hear or have the judge hear. It's a free shot. So that's a tip. So see my creditor responses. There's creditor responses. See my securitization responses. I've got it all up there. So that is your request to admit. Those are my show notes, which will be attached. But that's your request to admit response tutorial, if you will. Don't get intimidated, as I said at the beginning. It says attitude. You can actually have fun, because unless they're perfect in their question, they're not going to be. You can say, I have no idea what they say in objection. Facts not in evidence is a great one for me. And I think that's a good thing. If your whole case is they have not proven their case, and generally 99 times out of 100, they have that missing piece of the puzzle, it's fair game. You're never going to factually at trial show something that didn't exist. Now, if they later bring it in, you're good too, because that supports your answer that they were trying to sanction you on, because they brought in something they never did until now. So turn this into something positive for yourself. Don't forget why you are going to defeat them. Using their own documents against them, or lack of documents, so you can't answer. Now, let's talk about the one down and dirty, risky thing I did. So you'll see one to Rock Creek. So you'll pull my template, word template for Rock Creek. And I believe, off the top of my head, there was 28 requests to admit. By the way, that's a bullshit thing to do. There was a lot. I forget how many, but it's a bullshit thing that happens, especially in student loan. When you have them dead nuts where they have nothing and you can show it based on their own documents, they get spiteful. So they'll send you 28 requests for minutes because they know they're not going to win. But A, they're expecting you not to answer, so that's how they're going to win. B, it's like they're just being, you can read them. They don't make any sense and they really don't apply to the case. I've had so many cases from this one law firm that they send the same requests but different name of my client, exactly 1 through 50 or whatever. So I just take what I answered before because it's right, true, change the name, and that's it. And I've been doing this with them for 10 years and none of them have come back and changed anything. I always look, I'm always careful. Nobody signs anything unless it's the truth in my office, but they don't. And that's my thing. Most of these things you receive are bullying, spiteful tactics. With the foundation is they get to charge their client a bunch of money saying, hey, we did some discovery. And the case settles a couple of weeks after that. When I get a ton of stuff early in the case, I know the case is going to settle because, frankly, this is my opinion. I know they're billing the client as fast as possible because they realize I'm right and they're not going to go anywhere with this case and they don't want to subject their client to a judgment. So that happens. They bill a bunch of stuff. It's what it does. This is what attorneys do. I'm not specifically saying any attorneys are doing that. I'm just telling you my opinion of 30 years of litigation. Down and dirty, serious litigation. So look at that one I've titled Risky Responses. I just took all their responses, and at the end, instead of answering all 26 or however many he threw at me, I just said 1 through 26 is denied for the fact that there's no proof that this company, I think it's Rock Creek, has any ownership. Just look at my answer, counterclaim, counter affidavit. And that's as good an answer as any. The rule says I've got to either admit or deny, or if I've got an objection, back it up. Those are the 3 ways you answer. And I did that in one. I just said, look up all those, one thing. 5 minutes. And if it's true, and that's the only rule you live by, if it's true, I can do that. If it's honest and true and not trying to avoid or be evasive, I'm not. Just look at my answers. They have not proven that. By the way, when I did that, case settled. Guy had enough of me. So let's see if you don't have enough of me and you want more and you subscribe and you love and you like, because I love you. I love how well this thing is taken off. You're subscribing. My membership site, I listen to you because that's in a love relationship or any kind of good relationship is a back and forth communication. And I heard you say, Parker, great stuff, great content, but I am having trouble navigating this. So go look at the new site, 2.0, collectionstoppersolutions.com. And again, Getty Web. Make sure you take a look at lovely Natalie because she's got just put up her address again, Cindy. And that's who did that site. So let her know how good she did. Maybe you hire her. Believe me, she's the best. And so are you. And I hope this helps you with your request to admits. All right? Go get it, man.